This video is called How to Hide Assets from Creditors, Divorce, and Lawsuits Legally. And I want to begin by saying something that sounds backwards until you really think about it. The people who do the best job protecting wealth usually stop trying to hide it and start trying to structure it. That difference sounds small, but it is enormous. It is the difference between hoping your money is not discovered and knowing that even if it is discovered, it is still difficult to reach. And that is what this video is really about. And if you appreciate this information, please click the like button so they promote this video. Many thanks. And so I can see you again, please click the subscribe button if you haven't already, so that when more videos come out like this, you'll be up to date right away. And if you want to set up an asset protection plan or you have questions, please visit us at assetprotectionplanners.com. and you get a lot more free information there. If you're a business owner, real estate investor, a doctor, lawyer, an entrepreneur, high earner, or just someone who has spent years building something meaningful, you do not need fluff on this subject. You need clarity. You need to understand how wealth actually gets attacked, what most affluent people misunderstand, why timing matters more than almost anything, and what kind of structure changes your legal leverage before a lawsuit, divorce, creditor claim, or business dispute turns your financial life into a hostage negotiation. And I'm going to give you a fresh angle on this because the most overused angle on this topic is the sneaky movie-style version of hide your assets where nobody can find them. And that's the cartoon version. It is dramatic, it's catchy, it's also weak. Because in any serious case, especially where meaningful money is involved, people look. Lawyers look. Forensic accountants look. Opposing counsel looks. A spouse in divorce looks. Creditors look. If enough money is at stake, they will dig. And if your strategy depends entirely on secrecy, then your strategy is standing on a trap door. So here's the real payoff of this video. By the end, you will understand why what is hidden can be found, why what is protected can stay protected, even when found, and how a Cook Islands trust changes the pressure points in a legal fight. Why wealthy people often lose, not because they were wrong, but because they were reachable. And why one of the most dangerous phases in asset protection is, I'll deal with that later. But before I go deeper, let me give you a quick context. I'm the business guy from the Lawyers Limited Law Firm and Asset Protection Planners. I've been in asset protection for 35 years, setting up Cook Islands Trust for about 30 years. And our firm, they tell us in the Cook Islands, has set up more Cook Islands Trust than any firm in the world. I do not tell you this to brag. I tell you this because this subject gets polluted by theory very quickly. And I want you to know that what I am describing comes from decades of watching what actually happens when money, lawsuits, fear, leverage, and legal pressure points collide. Okay, now let's go ahead and make this human for a moment. When I was a kid, I used to save money in a shoebox on the top shelf of my closet. I thought I was clever. I thought I had created my own private little bank. In my mind, I had taken control of my financial future with cardboard and confidence. But there was always a problem. Even as a kid, I knew the shoebox was not truly secure. It was just hidden. And because it was just hidden, I always worried about somebody taking it. Somebody could stumble across it. Somebody could climb up there. Somebody could open the lid. And that would be the end of my brilliant vault strategy. A surprising number of successful adults are still doing the same polished, grown-up version of that same shoebox plan. The names are fancier, the paperwork is thicker, the bank balance is a lot bigger, but the psychology is the same. Let's keep this quiet. Let's put this here. Let's make this harder to see. Let's hope nobody really finds it. And that is not real security, and this is anxiety wearing a necktie. The key question is not, can they find it? In a serious dispute, they often can't. The key question is, what happens when they do? And that is the question affluent people really need to ask, because if the answer is they can freeze it, seize it, leverage it, and force me into a weak settlement, then your problem is not visibility, your problem is structure. And this is what I call the billboard test. If I could put the details of your structure on a billboard directly across the street from opposing counsel's law office, and they still cannot easily get to the assets that matter the most, then now you're playing the right game. If your plan only works so long as nobody notices what you've done, it is not nearly as good as you think it is. Okay, now let's talk about how wealth actually gets attacked. Most people think lawsuits are mainly about being right or wrong. Now, that is part of it, of course. But when money is involved, a lawsuit becomes a pressure point. The legal claim is one layer, the pressure strategy is another. Opposing counsel wants to access things that are reachable, visible enough to identify, and simple enough to collect. They want domestic accounts. They want exposed equity. They want business interests tied too closely to you personally. They want assets sitting in the same jurisdiction as the court issuing the orders. They want leverage. And this is why two people with similar net worths can have radically different outcomes in litigation. One person gets squeezed hard and settles from fear. The other person is still uncomfortable, still annoyed, still may be in a serious case, but the leverage dynamic is totally different. One person is vulnerable because assets are reachable. The other person has reduced reachability. And that is not luck, that is planning. Now here's the counterintuitive truth I want you to remember. Sometimes the issue is not whether you lose a case. Sometimes the issue is whether a loss automatically turns into a financial devastation situation. Wealthy people often think in terms of winning. Smart asset protection planning thinks in terms of containment. Can you contain the damage? Can you reduce how much wealth is easily within domestic reach? Can you make collection harder, slower, more expensive, less certain, and less attractive? Because when you change those variables, you change settlement psychology. Okay, now let's separate privacy tools from protection tools. A land trust, and we set up thousands of them, can be useful for privacy. A title holding trust, which we also set up, can be useful for privacy. Certain domestic entities add useful layers. I'm not against these tools, they have their place. But privacy is not the same thing as protection. A curtain is not a vault door. A domestic court can still have the power over domestic structures. If everything important remains under the practical thumb of the same system that is pressuring you, then the system still has a roadmap to your money. And that is where offshore asset protection becomes fundamentally different. Not because it is mysterious, not because it sounds exotic, not because people like palm trees and foreign words. It is different because it changes jurisdiction, and jurisdiction changes leverage. A properly structured Cook Islands trust, like the ones we establish for clients, is not relying on you being invisible. It is relying on the fact that the trustee company is outside of the reach of your local court. The trust is formed under a jurisdiction known for strong asset protection laws, and the legal architecture is designed to make collection profoundly more difficult. And here's the part that affluent viewers appreciate once they understand it. A good structure does not require you to live like a fugitive or act like you've just vanished into the mist. It is a typical structure. The Cook Islands Trust holds a Cook Islands LLC. While things are calm, the client remains the manager of that LLC. The client can have normal practical control while there is no active danger. In other words, you're not unnecessarily surrendering control during peacetime, but if serious legal trouble appears, a licensed bonded trustee company/law firm can step in when needed. And that shift is what really matters, because calm time control and danger time separation, that is the phrase I want burned into your brain. And why does that matter so much? Because control is wonderful when life is calm, and dangerous when your life is on fire. In fact, if you remain too directly connected to everything, when the pressure ramps up, your control becomes the handle that the other side grabs. But if your structure is built so that there can be real separation at the time of danger, you have changed the entire leverage equation. And that is not some technical footnote. That is the heart of the strategy. So let me make this concrete with a timeline-based scenario. Suppose Jonathan is a successful professional. He has a home with substantial equity, several $100,000 of liquid assets, a valuable vehicle, and interest in a business. He has insurance, but not enough to cover every nightmare scenario that could come out of nowhere. Right now, he feels fine because nothing bad has happened yet. And that is exactly when smart planning is easiest to do. If Jonathan waits, here's what often happens. A calm arises. Maybe it is a business dispute. Maybe it is a personal guarantee issue. Maybe it is a divorce that turned uglier than expected. Maybe it's a professional liability situation. Suddenly, Jonathan is no longer planning from strength. He is reacting from pressure. Every transfer now gets scrutinized through the lens of intent. Every moment raises eyebrows. Every step becomes harder, riskier, and less effective. The clock that once worked for him now works against him. But if Jonathan planned earlier, the story changes. Perhaps his home is placed into a land trust for privacy, with appropriate equity strategies used to reduce the amount of exposed value. We do a lot of lien structuring, for example. Perhaps vehicles are titled to structures designed to improve privacy and organization. Most importantly, liquid assets and other key wealth components are positioned inside of a Cook Islands trust structure through the right LLC underneath it. Nothing magical has happened. No smoke bomb went off. He did not vanish his money. He simply moved from shoebox thinking to vault thinking. And then a lawsuit hits. Now the other side looks around and sees that the easiest targets are not nearly as easy as they expected. Some domestic assets may still exist. Asset protection is not about fairy dust. It's about improving your position dramatically, not pretending that risk disappears. But the meat of the wealth is not just sitting there in a bowl on the kitchen table. The collectible pool looks different. The leverage looks different. The settlement dynamics look different. Jonathan may still have a stressful period ahead, but he no longer is walking into it with his financial throat completely exposed. Now let's talk about divorce for a moment, because people often make the mistake of assuming asset protection is only about random outside creditors. Divorce is one of the most powerful wealth transfer events in America. It is emotional. It is invasive. And by the way, we do this not just in America, but Canada, Australia, South Africa, UK. We do this all over the world for people. So a divorce, it's invasive, it's personal, and when it gets ugly, it becomes a forensic event. People look at statements, transfers, structures, histories, entities, timing. The same core principle applies here too. A weak strategy depends on concealment. A strong strategy depends on structure and timing. If somebody waits until the relationship is already collapsing and then suddenly starts moving things around, that tends to go quite badly. It is not sophistication. That is late-stage panic wearing loafers. The same is true with creditor claims. By the time you feel hunted, you have already lost precious time. One of the greatest advantages affluent people have is the ability to plan from calm instead of panic. We can still protect assets after the fact, but the options shrink and the costs go up. Yet many people do the opposite. They build wealth carefully and then protect it casually. So that's like buying a beautiful house and then putting a cardboard front door on it. Elegant, expensive, and a little too trusting. And another misunderstanding I see all the time is this. People assume the wealthy win because they hide better. No, often they win because they structure better, earlier, and more ruthlessly around reachability. They understand that visible wealth is not automatically vulnerable wealth. A billionaire can own obvious things and still be harder to collect from than a far less wealthy person whose assets are stacked in simple domestic arrangements with weak separation. Wealth alone does not create safety. Architecture creates safety. And this is where I want to dismantle another myth. Some people think offshore planning means you are doing something shady. No, shady is not the word. Strategic is the word. Legal is the word. Planned is the word. The law generally allows you to arrange your affairs, but before trouble hits. I mean, think about it. I mean, it's your money. You can do with it what you want. In fact, affluent people who fail to do this often are not being noble. They are being naive. There's nothing morally superior about leaving your life savings in a legally convenient position for somebody else to attack later. That's the money that you work hard to obtain. That's your money. Okay, now I want to be responsible here. Timing matters enormously. If a lawsuit has already been filed or a claim is already clearly on the horizon, transfers can be attacked as fraudulent conveyance. Now, fraudulent conveyance, by the way, is by and large a civil matter, not a criminal one. You generally can't go to jail for it in most cases. So, like I say, it's a civil issue, not some automatic criminal drama, but it can still wreck the effectiveness of what you're trying to do. So that is why I keep hammering the same point. Earlier is better. Calm is better. Planning is better. And this is not one of those subjects where procrastination matures into wisdom. It matures into regret. So that is also why I smile a little when people say they want to fully understand every detail before taking action. Now, I appreciate intelligence. I appreciate skepticism. Many viewers are not fools, and I respect that. But sometimes overanalyzing is just fear with a spreadsheet. People will drive a luxury car without knowing how the transmission works, sign a giant proposal and a guarantee without reading every line like a litigator, and buy investment properties in states they barely understand. Yet when it comes to protecting what they have built, they want a PhD in jurisdictional trust law before making the move. They upload the trust to ChatGPT and think ChatGPT understands asset protection. Trust, it doesn't. We've had clients try to do it, and they totally botch it. So meanwhile, the risk keeps aging like milk. I mean, I've studied case law, and I've been doing this, like I say, for 35 years, 30 of them setting up the Cook Islands Trust. So I understand what works and what doesn't. So what would the affluent viewer take away from all this? First, stop obsessing over whether assets can be seen and start obsessing over whether they can be reached. Second, understand that privacy can help, but privacy itself is not enough. Third, if you want serious protection, jurisdiction matters. Trustee independence matters. Timing matters. And the ability to separate you from direct control at the right moment matters. Fourth, wealthy people are not necessarily hiding better. They often structure better. And fifth, the strongest asset protection planning is usually done while life still feels calm and boring. And that is the most counterintuitive truth of all. The best time to build the vault is when nobody is chasing you. And that is not exciting advice, but this is the advice that saves fortune. Okay, now after all that value, let's go ahead and make one quick request. If this kind of strategy first thinking is useful for you, subscribe. I focus on practical asset protection, not generic financial oatmeal. And I want to keep giving you ideas that actually help you protect what you've built. And if you want more detailed information about how these structures work, you can visit us at assetprotectionplanners.com. And there's a lot there for people who want to go deeper. So let me close where I began. When I was a kid, I saved money in a shoebox and hoped nobody would find it. That is how children think about asset protection. Adults with real wealth need something better. They need stronger shoeboxes. They need a structure that does not fall apart the moment somebody looks in the closet. They need a legal vault, because what is hidden can be found, but what is properly protected can remain protected even when found. You could put that structure on a billboard across from opposing counsel's office, and if it's built correctly, the key issue is not whether they know about it. The key issue is whether they can do anything meaningful about it. And that is the shift from fear to leverage. And that is the shift from secrecy to structure. And that is how affluent people should think about protecting assets from creditors, divorce, and lawsuits. So this is the business guy from the Lawyers Limited Law Firm and Asset Protection Planners, and I'll see you in the next one.